Hello and welcome back to the DMA Stallard Employment Law podcast. And we're returning with a new episode sooner than expected in light of the announcements in the last few days in relation to two key things in relation to the retained EU law arrangements and the so-called sunset clauses, which we did a previous podcast on, which relates to the removal of EU laws from our statute books. And around the same time as that being announced, we had some announcements, and now in the last day or two, consultation paper around some proposals to reform employment laws. And so lots to talk about. And luckily, I've been able to get Rustam Tata and Stephen Tenhove back for this session, because it was the three of us who talked about the EU revocation bill in the first place, and we can get their takes, just initial reactions to some of these announcements, try and cut through and help everybody to work out what the real substance is in these announcements and the things to keep an eye out for in our employment and employer circles. So hello both of you, welcome back. Good to see you again. Shall we start? Let's start with the EU revocation bill and the changes to that. Obviously, when we all met before, we were talking about 31st of December this year, 31st December 2023, and being this big step change, a sort of cliff edge for EU law. Questions for you, Stephen. Is something still going to happen on 31st December? And if so, how is it different to what we thought was going to be happening on 31st December in light of this announcement?
Well, Adam, the government has reduced a rather more limited bonfire of EU legislation than it originally envisaged. To take us back a small way, in 2018, the government passed the EU Withdrawal Act. And one of the things that act did was to keep in place a huge number of regulations, statutory instruments, not acts of parliament, but statutory instruments, which were the consequence of EU regulations and directives over many years. We needed a properly functioning statute book, and unless this law continued, whole areas of the economy would not be regulated. Move forward 4 years to 2022, and the retained EU law bill has been proposed. And what that means is that as from the 31st of December this year, all legislation which is derived from EU law, other than acts of parliament themselves, will be sunsetted, to use a dreadful word. Now, that seemed at the time to be rather ambitious, and what has now happened is that Section 1 of that bill, which sunsetted these pieces of secondary legislation, has now been replaced by reference to a schedule of 600 pieces of secondary legislation, which are going to be sunsetted on the 31st of December of this year. And the others will survive beyond that date and will presumably be abolished over a great deal longer period of time. So it seems that the government has taken a step back from its original rather ambitious approach. And what we're seeing now is, instead of a large number of EU derived pieces of legislation going on the 31st of December, most will survive.
Yeah, well, I think maybe, Ruston, they were listening to you in government circles, because I know from our podcast we did before on this subject, I'm sure it was you that was talking about, the concern about doing this at breakneck speed, everything falling away in one instant, and the risks associated with that. So it seems to be a real softening of the position. Is it overall a positive thing from your perspective?
Yeah, I don't claim to have influenced government, and I think Stephen and I were certainly of one mind when we were talking last time just about it seeming somewhat reckless. And I think politically, in fact, we see the vote in the House of Lords just this week around that. In terms of ensuring that there is more effective scrutiny taking place before we sort of just ditch things. So I think, yes, it's certainly a change. And again, politically, over the last few days, we can see the fallout from some of that. It is a shift in the same way, perhaps, that the Windsor Agreement a little earlier on this year is probably a shift away from what might see as sort of Brexit purism.
Yes. Do we still have that change, Rustam, you mentioned when we last met, around case law and the supremacy of EU case law decisions in our domestic courts and tribunals, in the sense that there was going to be a change towards having a referral system? You could effectively fast track to a higher court in the UK to say, we want to depart from the EU law position on this thing. Essentially, we don't like the EU law binding authority. We would like the Supreme Court, or maybe a court below that, to look at it. Is that still going to be a change in approach from
Yeah, I mean, as
New Year's
I
Eve?
understand it, that's to remain in place. Although I think it probably should be paraphrased, if I may, slightly differently from the court saying we don't like it. It's rather the court seeking guidance in a similar and parallel way to what used to be the old Article 177 reference to the ECJ, or a domestic court to say, well, we're aware that the European provision says this. Can you help us understand how it should be interpreted and applied? And it's a very similar. We're slightly uncertain here, and we can see that it has ramifications. And that's because as it were, the lower courts, the Employment Tribunal, Employment Appeal Tribunal, will otherwise be bound by existing higher level decisions. So if they're aware they're bound by it, but they can also see that there may now be uncertainty in light of the revocation legislation, that the courts and tribunals will, as you say, Adam, be able to make that reference.
Yeah. So what we feels like we're sensing, or we're picking out from this announcement, is there's a slowing down of the pace of our transition. It may be part of a sort of slightly more profound shift. You mentioned the Windsor Agreement, Rustam, but interestingly, in terms of Stephen, you said the 600 pieces of legislation that are lined up for New Year's Eve. The dashboard, I think, Stephen, you introduced us to the dashboard in our last session, but what's happening to the numbers of, excuse the expression, pieces of legislation that are on the dashboard? Is it going down because we're slowing this process down, or is it going up?
It's going up, Adam, and I think this is part of the government's problem, that when it published this bill last year, it wasn't clear what legislation it was abolishing, and it's now done a wider consultation, and the number of relevant pieces of legislation increases all the time. To give you an example, I think that last year when the bill was published, it was thought that 2,400 pieces of legislation would be affected. That figure rose to 3,400 by the beginning of this year. When I checked last week, it was, I think, 4,870, and I checked this morning and it's 4,915. So in just a week, it's gone up by 50. And this is the problem that the government faces. If you want to abolish something, it's a good idea to know what you are abolishing.
Indeed, yeah. Do you think there's someone in Whitehall government that's just sort of has the job of spotting these and just popping them on, and slowly one person's adding them as the day goes by? Is anyone aware of what's actually going on in the system? And your point, quite well made, is what we're going to do. What are we actually proposing to do with it? Are we just taking it away, or are we changing it?
My understanding is that each department is looking at the bills that it has, and on the dashboard it's broken down by department, and so that is where this is all coming from. But the difficulty is that the job just gets larger as time passes. And I should make something clear about the schedule to the Act, which now sets out those pieces of legislation which are being abolished. In fact, several of those, if you look carefully at the schedule, and I can't pretend to have been through it all in detail, only parts of the relevant secondary legislation is being abolished. Some other parts are being retained. So although this appears that 600 pieces of legislation are going on the bonfire, in fact some are being partly put on the bonfire and partly kept for burning later, I assume. But the other thing we should make clear is that the other aspects of the bill will occur on the 31st of December. EU law, the supremacy of EU law will be switched off. Judges will be encouraged to revert to a more English common law attitude towards looking at statutes rather than the purposive approach that EU judges use and EU law requires. And the ministers in this country will still be able to restate and amend existing legislation, the so-called Henry VIII clauses. These all survive into next year. So it's really quite a lot of the bill, as Rustin said, provided it's passed, is still going through. Its ambitions remain. It's only this aspect of the abolition, the sunsetting of legislation, which is being very, very severely diluted.
That's good to hear. So I'm glad you said that, because it means we can say to listeners, if you haven't heard the previous episode that we did on this, it's not a waste of time going back and listening to it. There's still some relevance. We won't take it off the past episode list just yet. Now, if I'm not sure which of us is the most cynical in the room, but a cynic might say that it was an attempt to calm the Brexiteers who were certain to be very unhappy about this softening of approach. That was the reason why we also have had these, what I think we can fairly say are high-level announcements from government about how we are going to actively depart from EU employment laws. In some instances, we might say it's technically not necessarily a departure from EU employment laws, but just to make clear, or to seek to make clear, we're cutting our own path. Post-termination restrictions. Let's start with that. Which of you is keen on this subject? Wants to give us, in a nutshell, what's going on here? Yeah, right. Rustin's pointing at Stephen. Go on, Stephen. Give us the. Well, you. I know you do regularly cross swords or on your way to court on these matters. So that probably would be good for you to tell us what's in essence being proposed.
Well, the government has proposed, amongst other things, the other things being set out in its smarter regulation to grow the economy policy document, which it published last week. In addition, which I'm sure we'll discuss in a couple of minutes, in addition, it has suggested it will legislate to abolish non-competition restrictive covenants, which means your employer can prevent you from leaving employment and joining a competitor. They will abolish those unless they are less than 3 months long. 3 months or less. And the devil will be in the detail as to precisely how this will operate in practice. But I think it's a rather limited announcement. The government did consult about 4 or 5 years ago on abolishing restrictive covenants altogether, and that fizzled out, and this appears to be what remains. As a practitioner, it's quite difficult to enforce non-compete clauses. Judges simply don't like them and will only enforce them if they think that the departing employee has in their possession and is using trade secrets or highly confidential information. And so you would have to show that, at least in principle, if you were the employer seeking to enforce such a clause. But if you have that evidence, you can bring proceedings against the employee for taking your trade secrets and confidential information and injunct them on those grounds. You don't need an anti-compete restrictive covenant to do that. So this is rather limited, I think, in its application. And what also appears to be the case is the government will continue to allow employers to go to place employees on garden leave, for example. And so if you think that an employee is going to join a competitor, then stick them on garden leave instead, and make sure you can avoid damage to your business in that way instead. So I think that this looks like it might have been considerably more radical than it actually is.
Yeah, I mean, dare I say it? I mean, I've vacillated from one view to another about this proposal, but actually might be quite sensible given what you've said, in that non-competes are difficult to enforce in any event. You've always got the risk of litigation because there's uncertainty over whether a court will uphold them in any given instance. So if everybody knows, you can put 3 months and no more on that, and the focus needs to be on trade secrets, other information. I mean, you and I, Stephen, have been in at least one case where I recall that the risk with the court was its position would be, you've got a non-deal, you've got a non-poach, you've got 6 other or however many restrictions here, or why could you possibly need a non-compete? So it chimes in with that.
Well, exactly. And you have, and to be clear, the government isn't proposing to abolish non-soliciting of client clauses or poaching of employee clauses, which are what tend to be the major concern of most businesses. And the other thing is that we may currently have a difficulty in enforcing a non-compete clause at all. Along comes the government and suggests that it may well be legal, provided that you only limit them to 3 months. So it might strengthen the employee's position rather than weaken it. That is a possibility as well.
Indeed. So there might be some good news there. Rustam, any thoughts on that? Have we covered most of the bases?
I think I agree very much with what Stephen's outlined there. Yes, it's only the focus on that non-compete provision. It's just one of the provisions, which is usually the first one that almost when you're looking at on either side of the fence, you discount, and you really sort of get to the heart of it and say, well, what is it that's actually at risk here? Because what's it a court's going to uphold? I mean, this area obviously is very much around the courts upholding and enforcing property rights. I mean, in a sense, that's the sort of common law approach. So Stephen was saying, if there's some actual information which you can say is confidential to you, or if it's intellectual property which is capable of protection, that's what the court's looking to do, and that's slightly different from simply saying you can't go up the road and work for a competitor. And of course, we used to have non-compete clauses. I mean, I can remember going back quite a few years. I'm sure Stephen can too. People used to focus on the geographic extent. And is it within a mile? You used to worry, all the cases about hairdressers, was it within half a mile or whatever a radius of a particular office? With a lot of commerce and business now, and a bit hackneyed to talk about the global world, but obviously digitization, I think, means that except in a few service areas, it isn't so much about where you are, it's really about what you're doing.
No, that's a really good point, because it does link back to this business interests, doesn't it? When you talk about the property and the asset interest. The one thing the courts don't like to do, well, you can't argue that your business interest is a dominant market position, because the courts won't enforce a rule that just simply prevents competition. It feels to me like that's probably the angle behind this announcement. It looks free market supporting.
It's good. It's great. So sorry to jump in. It's a great sort of soundbite that we're trying to free up anti-competitive practices. But as I think Stephen's explained, in some more detail, the likelihood of simply being able to use the non-compete of itself and on its own without more is relatively sort of rare and unusual nowadays. So it's a great thing. I mean, the risk, of course, always is that the soundbite appears to present a general position that people understand and to be what the law is, whereas in fact there's, as we say, a lot more detail to it, and that's always, to be honest, been the case in relation to restrictive covenants. I mean, the barrack room lawyer is very quick to say non-competes are simply unlawful, and of course, as we know, there's a lot more to it than that.
Well, that segues us perfectly, Rustam, I think, on that subject of do people understand beyond the soundbite to what the actual legal position might be with these changes, to some of the other changes that we had, I think. Although before we do that, it might be nice to, even if we just touch on the irony of the smarter regulations, Stephen, do you want to just give us a quick summary of what the regulations about regulating in a smarter way are really doing?
Well, this is an announcement last week from the government on the 10th of May. Smarter regulation to govern the economy, and it's a policy document. It isn't really a regulation. It's a kind of announcement, but essentially it says that the government in future is going to think more carefully about the way that it regulates the economy and the things it's going to take into account when doing so, in the hope of regulating to grow the economy. And I think that it really is full of the usual bromides of government, and I'm not sure that it really makes much difference to the regulations that are going to be proposed in the future by the government. But it sets out the way the government will now be able to look at regulation now that we've left the EU. It emphasizes a sovereign approach, our ability to set our own laws. It emphasizes leading from the front with a focus on the future. It emphasizes proportionality. Where markets achieve the best outcomes, they'll be left to move freely and dynamically. They'll check and recognize what works, but they'll also set high standards at home and globally. So without being too cynical about this, I have heard all of this before, and it's really just the introduction to the rather limited reforms that they have proposed to what was EU governed employment regulation, which I'm sure we'll touch on in a couple of minutes' time. So my own view is it's the usual, we'll try and regulate better in the future than we have in the past. There's a specific reference to too much red tape burdening business, but these are the same references that the government trundled out in the 1980s and the 1990s for those listeners who are old enough to remember this. I can't see that there's anything fresh in this. It's just an attempt to reset us as a United Kingdom, producing our own regulations, and we can do this free from the EU, and this is what we're going to do. But what we're going to do is, as we'll examine now, is rather limited, it seems to me. And again, the usual justification is that it saves larger sums of money. The document quotes the £1 billion savings that the changes that are now going to be passed are likely to make. But there's absolutely no breakdown of where that £1 billion comes from. It seems to me to be a suspiciously round figure. So
Sort of figure you might write on the side of a bus.
Precisely. So what we've had is this document last week, and what we've got this week is the consultation paper about the various changes that are going to be made, which gives a little bit more detail, and I think is a little bit more interesting.
Yes.
But you might have had enough of my cynicism, and you might want to ask Ruston, because he might be a bit more upbeat than I am about the government's motives for this. But one can't help thinking that all this has been published at the same time, because the government's desire to have a bonfire of EU regulations has essentially been put on hold for a long time.
Yeah. Ruston, your reaction?
Yeah, no, I mean, I think I largely again agree with Stephen, which as he and I, and indeed Adam, you know, isn't always the case. But yes, but I think if we come on in a moment to the consultation document that's now been issued in the context of the employment law changes, the first 4 or 5 pages are effectively political polemic, saying where government's trying to, I suppose, ride a number of horses, and I guess it was ever thus. But very much the introduction talks about how in the UK we have great employment law, employment protection standards, and that effectively we'll continue to have those, notwithstanding the fact of departure from the EU. As you'll know, 2 of the areas where there was considerable concern in the context of leaving the EU was around employment rights and worker protection, and of course environmental protection as well.
Yeah, well, you're right, and you read those initial pages, and you look and sometimes reading it and thinking, well, how do you reconcile maintaining these high standards, indeed highest of standards, that talks about how we have, in some instances, the highest standards in Europe, and also make things easy and be regulated for business?
Yeah, I mean, there's lots in there. I mean, you could do a whole separate podcast on that, but I suspect that would put some people to sleep about whether or not we did have and have had particularly high standards. It's like everything; it depends who you compare yourself to. I mean, just quickly, our race discrimination legislation was far more developed than has been the case in Europe. You look in the 1970s. But some of the advances and developments in the context of sex discrimination and other areas probably further advanced in the European context. And so the UK's quite been dragged screaming and kicking, but it's had to catch up.
Yeah. There's one point in the initial preamble I wanted to put to you both. You will have seen it. All 3 of us had a look at this consultation. And just to be clear, we're talking now about the retained EU employment law consultation paper. This is Department for Business and Trade, which came out within a few days of that 10th of May announcement. We've only had it a couple of days for the 3 of us to have a look at. But it talks about these promises and commitments it's making in this area that both of you have just summarised, essentially. And it says, we will ensure retained EU employment law, for which certainly Department for Business and Trade is responsible, is preserved in areas where we are not either consulting on reforms, which is what we're about to talk about in relation to working time, regs, holiday and TUPE, or revoking it because it's irrelevant. So it seems to me to be a pretty clear statement that we're not going to let anything fall away unless it's consulted on, and unless it's being actively consulted on, or it's totally irrelevant. So that talks to that new message, doesn't it? But seemingly what we're all saying is At the same time, they feel this sense, they feel the need to be very clear that we are making changes to try and appease those who will say that's completely is at odds with what the original bonfire of laws was going to be. It stood out for me as a statement.
It is difficult, and it would be difficult, obviously, for, I don't think it's a matter of the colour of the political persuasion of the government, but I think it is difficult, as it were, to, on the one hand, saying we're really making effective change here, but on the other hand, saying we're not changing very much. And that's essentially the two horses that they're trying to ride. But I mean, I think just looking at the three areas that you mentioned, Adam, and just going perhaps first of all in relation to working time regs, the initial ministerial announcement appeared very much just to be focusing on keeping of records, the employer keeping records for night workers. What's in the consultation document is a lot broader. Now, one could say, do you need to keep records in the context generally of the 48-hour week, which obviously, as we and all the listeners will know, is not even as simple as 48 hours in a single week, but it's 48 hours on average over the relevant reference period, 17 weeks or longer. But I mean, if the government is saying it's not necessary for employers to keep records in the context not just of night work, but also the 48-hour week, you can see how that's going to enable, some will say encourage, unscrupulous employers at least to effectively say, just argue and say we haven't kept records and deny or argue that individuals have worked more than 48 hours. So I think if you retain the substantive right, then actually the administrative, in inverted commas, burden or obligation that goes with it, as long as it's sensibly done, and I don't think the issue here is really a problem. If you then remove the need to keep the records, all you do is you encourage more litigation around whether or not the person did or didn't work the hours. You don't have a mechanism for checking it. And actually, most employers will say, most responsible employers will say, well, the employee will remember or will argue which hours they kept. So actually, it's in our interest to make sure that we've maintained a sensible system. So it's a bit of a, as usual, obviously, a bit of a kind of mixed bag. I mean, I think it's relatively easy with night workers or perhaps with younger workers where you might say it's really important from the point of view of protection that proper records are kept and that there is a formal obligation to keep those records. But as I say, in the context of something like the 48-hour week, I'm going to talk about holiday pay in a minute, but again, where you will, as the employer, want to keep sensible records so that you can justify the basis upon which you've paid or not paid somebody, either for working time or for holiday.
Yeah. Well, there's a great summary, and the consultation invites until July, I think it is, feedback on these proposals. On this one, it talks specifically about, do you agree or disagree that we should clarify you don't have to keep records? So I encourage people to look at it. Anything from strongly agree to don't know. So you can be in any category from that, in that range. But I think you make a very good point about, if nothing else, you've got the point about rights for night workers, etc., in certain categories, but wouldn't you want this record so that it removes an area of dispute you might end up in litigation over? You mentioned holiday pay. Let's jump to that. These high-level announcements. The consultation paper gives us a little bit of a clearer picture on that as well, doesn't it, Stephen? There's two areas I think there. You can maybe pick them up. There's how do we express our holiday entitlement under the UK, under our law here, and then how is holiday pay calculated? And it's probably the latter of those two. We should cover both. That really is looking particularly interesting and will be very interesting to employers who've post-Brazel been grappling with this issue right now and recently.
Yes, Adam. The simpler one first, which is that the government is making the announcement that the EU entitlement to holiday pay, regulatory entitlement to holiday pay of 20 days, has always been supplemented in the UK by an additional 8 days. And so, in theory, EU law applies to the 28 days, to the 20 days, and UK law applies to the 8 days, which is anomalous, and they're right about that. And they're going to apply the same law to all 28 days. I'm not sure what great difference this makes. I don't know a single employer who differentiates between the 20 days derived from EU law and the additional 8 from UK law. But it's going to be one entitlement to 28 days, and all your rights are going to apply equally to those 28 days, as I can understand the proposal, and that seems to me to be eminently sensible.
Hmm.
The more
Other than maybe
interesting,
a slight a frustrating dusting down of your employment contracts that talk about splitting it between 20 days plus bank holidays, and how does that fit with people who are working different patterns? But I suspect that was probably needed at some
I
point
think there
anyway.
are I think there are some employers. There are now. Stephen and I won't agree
Oh,
for a moment, so
oh,
that's
good,
probably
good.
we thought this point
Um,
was boring. We're going to get a bit of debate going on this point.
I think there are some employers who, in some instances and contexts, will draw a distinction between the 28 days plus the additional days. One of the areas is around carry forward. One of the areas around carry forward also in the context of long-term sick, in terms of what the employee can claim and as it were, be paid for. And certainly one's seen contracts and situations, they are more the exception rather than the norm, where it's said you're deemed, first of all, to have taken this entitlement rather than that entitlement. And similarly, of course, if you get into the detail of dismissal for gross misconduct, what that means in the context of accrued holiday pay. But I completely accept the central premise of what and agree with what Stephen's saying, which is that for most employers, having two different systems and two different situations to calculate holiday pay is just seen too much like hard work. Not least because you have to explain it to the employee. You know, why are you paying me this and why don't I get that? And by the time you've gone around that loop a few times with a handful of employees, you just say it's not worth the candle.
Yeah,
precisely. And
now, let's look. Sorry, Stephen. Let's look at pay. While we're sort of coming close to time on our whistle stop tour of this stuff, and this is around, and this, you and I, we both touched on this before we started this discussion, that it's actually page 17 for those of our listeners who like to delve into the consultation. Sums it up, and it's holiday pay, and it's saying, you know, at the moment you get your normal remuneration as set out under case law. That can include commission, bonuses, overtime, the British Gas decision, all of that case law we know. Plus we've got appraisal and that stuff around. And then on the right, with the proposal of what will happen next, there are 5 words. 1, 2, 3, 4, 5. Yes, paid at basic pay rate. Does not need to reflect normal remuneration. That is a massive change, I would say, on the face of it. Obviously subject to any exceptions that might come through in draft regulations. But
yes, I think that's right. And that wasn't in the original announcement last week. It's buried in this consultation document. And I think that will be very interesting. The government has an opportunity to greatly simplify what pay means for the purpose of calculating holiday pay. And it looks like it may take up that challenge. But we'll see.
Yeah. But for all our employers listening, I encourage them to look at the consultation and who've been grappling with this and the anxiety around how do we properly calculate now. Encourage them to look at the consultation and put a tick in the strongly agree box, and hopefully it won't get watered down too much from here to actual legislation, I guess, would be my hope for the employers that I'm working with who are grappling with this issue.
What are you suggesting there, Adam, that it should be at basic rate only?
As the almost overwhelming default position, yes. Now, I know you're now going to tell me, what about though the person who does this?
Yeah, absolutely. I disagree. I think it should be an average over a period, because that most fairly reflects what their pay is and has been.
Does this go to the then, Rustin, that we talked about moving away from EU case law and jurisprudence? I think it was from the EU position that we started this idea of a holiday is for rest, and the arrangements for pay must not discourage people from taking it.
Yeah.
So we inevitably dislocate ourselves from that line of reasoning and go, no, it isn't. It just needs to be normal pay. And Mr. British Gas, who couldn't go on holiday because he would lose his commission and wouldn't be able to buy Christmas presents, will just have to arrange his financial affairs better. That's not my personal view. I have no offence to Mr. British Gas. I can't remember his name. Locke. Mr. Locke. Forgive me, Mr. Locke, if you're listening.
Well, so I think there's 2 points. I think there's what should the calculation be, and I think you get obviously even to British Airways and other cases about allowances and particular allowances and whether they should be considered part of base pay. I think we've moved away generally in employment law from a situation, if we ever had it, whereby the label becomes determinative of the substance of the right. So if I think in the context simply of employment status. The fact that we might call somebody a contractor doesn't make them a contractor. We look at the substance. So I would similarly say that if pay nowadays is considered to include most entitlements beyond simply the basic rate of pay, that I would say that that should be included in the holiday pay calculation. But I appreciate that it's continuum, and obviously the modern move is towards talking about pension as deferred pay. So at what point does that fall into it? But I think we've got the other point here, just in this context, Adam, which is that it looks like we might now have more of a dislocation between the timing of taking of the leave and the timing of payment. And you're right, certainly it was some of the EU-based jurisprudence that emphasised that the pay should pretty much be at the time that the leave is being taken. And one of the reasons for that is so as to encourage or not act as a deterrent to the individual to take the leave.
Yes, indeed. Risk, I fear, of ending on a damp squib, full disclosure, in that the remaining item on our list is TUPE and the changes to TUPE. And so it's a bit of a spoiler there for the listeners. But Stephen, why am I saying we might be ending on a damp squib when we talk about TUPE here?
Well, TUPE is a piece of European regulation, which, if you wanted to be radical, you could dispose of. What the government has decided to do, I think, sensibly, is to tweak it in a very, very small way. And it simply eliminates or it proposes to eliminate the employer's obligation to have employee representatives where the fees are between 10 and 49. I suspect that most employers who are contemplating a transfer undertaking with 40 to 49 people in particular would want to have an employee representative anyway as a mechanism to deal with the number of employees that they have to consult with. So I doubt that'll have much impact on day-to-day practice with TUPE at all.
Yeah, it may not be a solid ground to rely on as an employer as well if you're going to rely on the exception, if it's based on number of affected employees, it seems to me, because how many employees are affected by a transfer can be a point of dispute in and of itself. It tends to be pretty clear how many employees are on your payroll, which is the current micro business route. Once you start saying, well, it's affected employees, if you're around the margins of that, where you're on the number, it only takes one person to pop out, what we call woodwork employee, and go, no, I was affected as well. And have you just then landed yourself with a protective award liability?
You have, so you're bound to be cautious, and the regulation, I think, is a sensible one. So TUPE remains more or less unamended.
Okay, so wrapping up then, what's the big announcement? One big announcement from each of you. You may well agree on this. We've had a lot of agreements today. I haven't managed to engender much disagreement and tough talk, fighting talk, but go on, Stephen.
Mine, I think, is how you calculate holiday pay. And the government will seek to simplify it. It will look good in a news headline, and employers will think that they're getting something as a result of leaving the EU, and a whole load of case law, which they find surprising when they read it in the newspapers, will be abolished to stroke. Whether that turns out to be the case or not doesn't really matter, but politically, I think that's an interesting move.
Ruston, anywhere else to go on that? Can you throw us something?
Yeah,
I mean, this is 12.07% coming back. Stephen's picked a strong one there.
That's fine. I'm happy for Stephen to have that one. I think I'd pick up with what I was saying earlier, which is it would be the irony of ironies that the UK government, having made such a big deal about having an opt-out in the context of the 48-hour working week when the legislation was first introduced, that we end up essentially through the back door by a lack of requirement to keep records for that right to effectively wither one way or another, or to be brought into disrepute. So that's a bit more out there for you.
Yeah, thought-provoking. Well done to pull that out from under the shadow of Stephen's holiday pay point. Thank you both. We're now left with 600 pieces of legislation proposed to be going on New Year's Eve, rather than many more. and a slower process. So, but it did occur to me, chaps, that 600, if I'm right, is the number, rode into the valley of death in that famous poem. Let's hope that's not a foreboding coincidence in this instance. We will, of course, come back to this subject nearer to New Year's Eve, I'm sure, to then touch again on what clearer position we're in regarding our transition away from EU law. But in the meantime, just remains for me to thank you, Stephen Tenhove, Ruston Tarter, for your time. Thanks to everybody for listening, and we will see you soon on another podcast. You can follow us on our LinkedIn page and web page, and there'll be reading list of materials on the website as well. Thanks for listening.